It's a privilege for me to be part of this series, and I'm going to be looking at human rights impact assessments from the perspective of an advocacy group. We advocate for a child rights impact assessment. And just to help us through the talk, I'm going to call that a CRIA. So the Child Rights Impact Assessment is abbreviated as a CRIA. I hope to look at why advocate for a CRIA, strategic reasons, potential benefits of it, some cautions, concerns that we have as we move in this direction. We're not doing it with our eyes shut. Some lessons from the experience in other countries. And then that leads us to what are some of the essential components of an effective CRIA. And finally, I want to just add with a note on CRIA, human rights, and federalism, because our context in Canada is federalism, and it becomes a major issue in all children's rights. That seems to happen in children. So, you know, that's where all the money's going, that's where all the interest is, not looking at other factors. We hope it will contribute to evidence-based program design. That's why we say systematic analysis of proposed changes. We're talking about CRIA as something that happens at the beginning of a process of changing law or putting in place new policies. And as such, it complements monitoring. Most of us have been involved in monitoring human rights, which is an activity you take a look backward. What happened? What went wrong? What rights are being violated? We hope that CRIA gives us a tool at the beginning so we can talk about human rights and an assessment at the beginning of human rights. We think that that's particularly important for children because early life has lifelong impacts, and 5 years is a long time in the life of a child. It's 5 years between a review, and then it's another 5 years perhaps before change happens. Most of the time we lose a generation before change happens. So we think that by proposing a tool that looks at things at the beginning, hopefully we could move forward on that. It is a rights-based assessment. That's essential for us. We believe that the Convention on the Rights of the Child provides a solid, comprehensive framework for public policies affecting children, and so it would be the reference point for any assessment. And I think we find in children's rights that the laws that are designed for one good at the end, often have unintended consequences. And we'll talk about a few examples through the presentation. And we think that a children's rights impact assessment could also help in that regard. So that's why, by definition, we want to look at all kinds of impacts, not just what's being targeted, but what else is happening when you make those changes. And we know that the cost of negative impacts is greater than the cost of doing an assessment up front. I'm going to look now at why children's rights impact assessment for strategic reasons. This is looking pretty much at Canada. Children, we're talking about children under the age of 18, are 25% of our population, but they have no political voice in the public decision-making process right now. They're pretty much ignored in policy debates that do affect them. I'll give you one specific, easy example. When we debated tasers in this country and taser use, there was no separate look at young people. Tasers are used on young people. The impact for young people is very different than for adults. Through the whole debate on tasers, no one looked at the question, what about young persons under 18? We don't have a separate policy for that. Our police forces don't have separate guidelines for that. So children tend to get ignored. Canada's is an aging population, and that means there's going to be even more focus on people like me and less focus on young people. But it's our argument that developing the full potential of children is even more important because we're an aging population. Canada cannot afford to continue to let so many children fall through the cracks. That's a central thesis of the coalition, and we do make some gains even in a government that's not so attuned to rights with that kind of an argument. So it makes good economic sense to be looking at the impacts of policies for children. I've already mentioned that early years have a lifelong impact. That's one of the strategic reasons. Also, we hope that it would bring human rights into the policy formation process early. In existing Canadian policy, there is a requirement to check human rights when things go up to cabinet. That's there, that's regulated. It's not used very much, it's not well developed, but by proposing a more robust impact assessment, we're advocating to improve something that exists. And sometimes it's easier to do that than to be advocating for something entirely new. So part of our debate is, you do this little checkoff now, why don't you make it mean something and do a good job of it? So we think that gives us a strategic advantage. And it puts children's rights on the agenda early. Very practically, we believe that the use of CREA would reduce harm for children. I'll give you another easy example. Changes were made to the Citizenship Act in Canada in 2009 for some other good reasons, and they ended up creating stateless children, which is a harm to children. They have to get benefits, they don't have a state identity. The government had to go back and change them. Had they just done a proper assessment from the beginning, it would have saved them costs, it would have saved harm to children. We have a parent in the room here whose child experienced some lack of identity for some months. That's serious. So we could avoid harm by doing this up front. I want to say that we see child rights impact assessment as only one tool in a toolbox. It's not a panacea, it's not the ultimate. We advocate for other tools too, like making children's rights part of domestic law, a children's commissioner, better monitoring and reporting. But we do think it is one tool that perhaps it's time to move forward with in Canada. So then what are some of the potential benefits? And I'm going to spend probably the most time on this. All right, then what are the potential benefits? During the third review, which we just completed, the Government of Canada could not provide to the UN Committee some very basic information about children in this country. One of the things they could not provide is an accurate account of how many children are in care. To me as a Canadian citizen, that was shocking. We live in a highly developed country, and we could not provide pretty basic information. And this was about children who are in the care of the state in various places in the country. So one of the outcomes of moving to impact assessments is getting good data. And the next one that's even more important is analysis of that data. What we also experienced in the third review was that they would bring a little bit of information from here, a little bit of information from there, and use that as evidence that we were improving on children's rights, without any analysis of that data to give us a good, solid picture of what's happening to children in the country. We think that CREA will force better data collection and better analysis of it. Also looking at impacts on different groups of children. And if you look at the outcomes from the third review, time and again, Canada is asked, what about the impacts for Aboriginal children? What about the impacts for immigrant children? What about the impacts for girls versus boys? We don't have data. We didn't have it as an NGO to bring it to the table, and we don't have it as a government. So better data is one of the first things. Secondly, and I think this is the most important perhaps, is we hope it could create a space for substantive dialogue that's not overly politicized and overly polarized. If you have it early in the policy process, before things are moving up to cabinet, before the minister has already, nailed his hat to a policy, perhaps we could have a better dialogue about options, about what the problem really is, and so a space for that kind of discussion. Many officials will tell me they wish they could have that more open dialogue, but in fact, we end up reacting after an announcement is made. And so it's always reactive, it's always then politicized. So we hope a CREA would be a different kind of policy space. One specific thing it might do is to be able to resolve conflicting claims about rights. There are tensions, and again I'll give you an example. The move to allow parents to take their children out of sex education classes in education systems across the country, it's moving across Canada, responds to a parent's claim about their responsibility and their rights to provide guidance to their children in this area. But what's not being looked at is the young person's right to access information that's vitally important for them and can be vitally important for their health. If you look at the provisions in the convention relating to those two things, what you find is that both of them refer to a concept called the evolving capacities of a child. So in fact, if you had more of a policy discussion up front, your debate might move away from just a parent's claim versus a child's claim, because both of those are legitimate, but to the question of when does a young person have enough capacity to take those decisions for themselves. And we might have more of a graduated policy on this kind of a question than we now have, which is one side won and one side lost, in my view. And Alberta is entering in a whole new level of debate on these questions right now, but we don't have time to get in that here. Another benefit is that we hope it would remove research to policy. There is a lot of good research on children in this country, on the social determinants to health. We know what we need to do for children, but it doesn't come to bear on policy decisions, and we think a CREA could help with that. You know, there's one pediatrician who's a member of our network who has studied brain research and knows what's happening to young people's, to children's brains. He thinks it should be a crime in Canada how we allow young children to grow up in unhealthy circumstances, because he knows what's happening to their brains as a consequence of that. That research doesn't get into the policy process, and we would hope a CREA might do that. I think I've already mentioned a bit avoiding unintended consequences. We think that a CREA could really help us avoid. What do I mean by unintended consequences? Well, sometimes policy choices are made for a good end in another area, but the consequence is something entirely different. And maybe I can give you this example. Paying foster parents of children more money if children are on drugs was intended to recognize difficult cases and that there's an additional responsibility for parents. What the consequence was when I listened to some young people was that they were being encouraged to take drugs or sometimes forced to take medications that they didn't want to take, that had adverse impacts on them from their perspective, because their foster parents were receiving more payment if they were on these medications. Something went very wrong here in the policy process. And again, we think that by looking more carefully at the impacts before you move into a policy area, we might identify and avoid some of those unintended consequences. Then there is the question of integrating government agencies. Children's rights constantly fall between the cracks of federal, provincial, health, social services, education, and we hope that a CREA could help us bring these together. Right now, the response to different jurisdictions is to establish working committees. I think there are 9, 10 federal, provincial, territorial working committees that see mid-level officials travel across the country to talk about very narrow slices of a child's life. They're usually not able to really make many decisions. They're usually limited by their own department. A lot of money is being spent. I find very little evidence that children's lives are better off for many of these committees. I don't think it's a tool that's worked for integration across governing bodies. We think a CREA has a better chance at that. Practice in the end will only tell us. And then for the coalition, of course, using the convention to shape policy is the biggest benefit. We still find in this country 75% of young people don't know about the convention. Officials don't know about the convention. If they were forced to use it in the policy process, at least some officials would need to read it. We hope that it would also lead to greater public awareness of the convention, and so that alone might be enough benefit to move to a CREA. Confident we will show benefits from doing that. As I mentioned, the change in the Citizenship Act, it would have saved them a lot of money. And any of us around a table, if they had asked us what's the impacts of this, would have told them, you're going to create stateless citizens. And they could have checked some things. So I would hope it helps to broaden the discourse about human rights, to make it more understandable, and to show positive benefits rather than us constantly being in the space where we're trying to name violations and corrections. I would like to, I don't think CREA will depoliticize in the sense that we are going to make public policy choices, and those ultimately is a political debate, but I hope it would be more well-informed as a result of this kind of process. So, for example, again, going back to the issues around sex education, you know, that they're looking at both sides of it, and in fact, there's a better option than the two that are on the table right now, which is, you know, totally legislative. If you really took children's rights seriously, I think we would come up with some better options. Ultimately, yes, it's still going to be a political debate, and that's fair. And I don't want to take children's rights out of the political arena, but to consider them at the point of options, I would argue might give us some better choices in the public arena. In terms of federal, provincial, I think it's going to depend on the issue. One of the reasons we're interested, though, is that some provinces are interested. And in fact, New Brunswick is very interested in exploring this. And so if we have provinces using it and showing some good models, that's one way change happens in Canada. Children's rights ultimately get very tied up in federal, provincial. At the end of the talk, I hope to get into this a little bit. But if provinces are willing to think about using impact assessments for policies in their area, I anticipate it's going to show also where some of the gaps are between the federal and the provincial. When it came to Bill C-10, the changes in criminal justice, we were dead up against provinces and federal government. Provinces administer the law, the federal government makes the law, and there were real differences about the impacts for children. And could we have sat down and looked at that one with both players at the table, we may have come out with a better bill on criminal justice. So in that case, I would say they're both at one table, but we're keen that some provinces are interested in applying it themselves. And I think that will contribute to an ongoing learning in Canada. All right. Moving on, and in terms of looking at some of the benefits from a human rights perspective. How will it advance children's rights? And I'm going to just focus on some of the big principles in children's rights because we can't go through 45 provisions of the convention this morning. Best interest of the child should be top priority for decisions that affect children. This is sort of a core principle in children's rights. It puts the focus on children instead of adults. That's its benefit. But it's a very general principle. It's been a much misused principle. Residential schools in Canada, I just need to say the word, and you'll see how misused it can be. We would say that the process of determining the best interests of children needs to be informed by all the provisions of the convention. And we think that a child rights impact assessment could help to do that. Current provincial child welfare legislation, most of them have reference to the best interest of the child in it. I can tell you it's interpreted all sorts of different ways, and a lot of us in the rights community have a critique of how it's being implemented. So in fact, bringing that onto the table, how are you determining the best interest of a child? We think that that could be one of the benefits. Non-regression. The Convention on the Rights of the Child talks about a progressive realization of children's rights. And the first lecture in this series spent some time in what that means and that it implies non-regression. So I hopefully can move quickly to the non-regression question. So, you know, we can't fulfill all children's rights tomorrow. It is related to the capacity of the country. But your obligation is to keep moving forward and not move backward. And we think that a children's rights impact assessment tool would flag those areas where a country is moving backward. Canada has been moving backward in a few places in the last few years. We think more and more. But most Canadians still think Canada's doing very well on children's rights because they compare us with some countries with a much worse record. And that game is really difficult for us as an advocacy group. When we want to try to say Canada isn't doing so well, look at Iran. Or when we were at the third committee, they said, look at Syria. It's a woman from Syria criticizing Canada. And we lose the debate. I think by getting into these kinds of tools, we begin to look at where is Canada going backward. And if the public becomes aware that we're moving backward, I think we'll see a higher level of concern than we have now. The other is progressive realization. So how do we move forward? And put positively, we think the CREA could highlight opportunities to make gains that we're now missing. And again, I'll try to use an example. Sometimes just a small change in a program could help to fulfill many more rights. This government announced a plan to prevent injuries for children. We immediately said, can you broaden the definition of injuries to include intentional injuries as well as non-intentional injuries? You would be moving to fulfill more of children's rights in terms of preventing all forms of violence against children. And that option was understood by officials. We did have some discussion about it. I know that the option was outlined. At the end of the day, the government chose to spend the $5 million on hockey violence alone in response to news stories about concussions. So we went backward. But we could have made a big gain by being able to discuss that perhaps earlier, before it was even framed. But how do we measure progressive realization? How do we talk about that? I think a CREA process could help a lot. The first call principle in the Convention on the Rights of the Child says that children have first call on the resources of the country. So we have said, for example, when it comes to cutbacks to meet a deficit, you should be protecting at least the most important programs for children. How do you measure that? And the measure is you're supposed to allocate the maximum of your resources based on capacity for children because they're the most vulnerable. We have no tools right now to effectively measure whether that's happening or not. We would see that being part of a CREA process. And again, I think the public is on side with saying children have a measure of first call on a country's resources. But we don't debate it that way because we don't have that level of information in front of us. And then the most important one for us is equitable treatment. The report from Canada's third review names evidence of non-equitable or inequitable treatment in several areas. And Canada was asked to address that in the second report, in the first report. Nothing has changed in terms of a tool to address equitable treatment of children. Research done outside the government has established inequitable funding in areas like Aboriginal child welfare, Aboriginal education. That information has been supported by the Auditor General. The department insists it's not inequitable. So we have said there should be a children's rights table where you put that information on the table and we work through it. Is it equitable or is it not? I think that information will come out at an upcoming hearing at the Human Rights Tribunal, but that's after millions of dollars have been spent hiring lawyers. And Aboriginal children have continued to go to inadequate schools. So if we could have addressed this question of equitable treatment in a forum, put the goods on the table. I said to the responsible official, put the goods on the table before the UN Committee on the Rights of the Child, and we'll evaluate whether it's equitable or not. I think that could happen at CREA, and we could do that kind of discussion well before so much damage is done to children from agriculture. Now, I would argue CREA does not replace having a complaint process and having access to redress. It's not a replacement, but it's an additional tool. And I can tell you what the likely outcome would be, what we know happened at the roundtable, which wasn't a CREA forum before Bill C-10 was adopted, but there was a roundtable of some folks involved in the criminal justice system, and they clearly said, we get better benefit for dollar from prevention programs when it comes to youth justice. And if we could make that argument well substantiated more clearly as part of the policy debate, it would have informed Bill C-10, which is turning back to more punitive, less preventive, and the money is going to go into building prisons instead of the kind of programs we know work for young people who fall into the criminal justice system. So at that level, it could help with that and inform that debate. Any other questions? All right, some cautions. Go ahead.
Oh, I was just wondering, just on that note, like this kind of, there seems to be this kind of resistance, at least it appears based on this year, to evidence-based actual information and then making policy decisions based on evidence. And so do you guys feel that that is a challenge for you as well? Because this is very evidence, you know, like let's gather information. Actually, we've seen like slashing of many organizations and funding towards these organizations that do specifically that, gather statistics and gather facts.
There is a resistance to evidence-based, but I guess we do see this approach to evidence-based because it would come in early, before the minister has hung his hat on a policy option. It might be more accepted than when it comes in, weighed in on a punitive or on an afterward you failed basis. Also, frankly, we're trying to there is a resistance to evidence-based, but I guess we do see this approach to evidence-based because it would come in early, before the minister has hung his hat on a policy option. It might be more accepted than when it comes in, weighed in on a punitive or on an afterward you failed basis. Also, frankly, we're trying to promote CREA a little bit on the grounds that you have it in your policy process now, that you do a rights check. You say you do it, you're saying in Parliament you're doing it, you told the UN committee you did it, they told the UN committee, we do believe in fulfilling our obligations under the convention. We need to take those quotes and use it for all they're worth right now. Say, you said to the UN committee, you believe in fulfilling your obligations. Here's a tool to do it. Your process has a checkbox. We think there's something better on offer than the checkbox approach. We think it has added value for you because it will save you money. It will save you policy embarrassments. The children's rights cuts, some of the health care cuts for refugee children is another one. It did cause, they had to pull back on some of what they did. Had we done a full CREA assessment, we wouldn't have gone that route. So I think it can be proposed to officials and MPs as something that avoids them political activism as well. Moving on to some cautions. You know, this is not all a rosy picture. So I want to talk a bit about caution. We're not going into it with our eyes shut. If it becomes another checkoff, it's not going to be an advantage. And maybe I've said enough about what the current process is for you to know that. But I will cite the recent experience with Bill C-10. Does everybody know what that is? It's the major changes to the Criminal Justice Act that Canada just did. All right? We asked for a child rights impact assessment of that. We positioned some senators to ask for that. The Minister of Justice came before the Senate committee and said, my officials do an assessment, and the changes we propose are compliant with the convention. They fit with the convention. And all the children's rights organizations, some members of Parliament, the UN committee, asked to see this assessment. If you're saying these changes follow through on the convention, can we see that? Can we see that document? Nothing was produced. We then did an access to information request. The minister said an assessment was done. Can we see it? In front of the UN committee, I just should fill in that piece, the justice official cited 2 changes that in fact are improvements under the convention, but said nothing about 4 changes that are regressive. That's what happened with the UN committee. So again, we asked to see the document. The answer to the access to information request is there is no document that matches the description of an assessment. So the current process is clearly weak. Either it's not done at all, or it's so weak there's no paper associated with it. But if a CREA falls into that same trap, we haven't gained. We cannot obtain a document to back up the minister's statement. An assessment was done and it complies. There are going to be methodology disputes. This is a new field. Other countries are moving into it. I'll talk about that a bit, but there will be methodology disputes. And there is a risk that sometimes what should be a discussion about the merits of a policy option can become a dispute about the methodologies involved. And then children don't benefit from that. So we do need to work through that. There could be delays. If a CREA becomes an overly complex and bureaucratic process, it could result in delay of changes that need to be made. And I'll explain when we talk about essential components how we think we can address that. A bigger concern of mine is that rights becomes technical measures only. We see that happening a bit also in the monitoring front. But if rights work just becomes, scientific indicators, that academics to scientific standards go out there and measure things, we will have lost something very important in children's rights and advancing children's rights. Why? Because communities and young people can never produce evidence to that standard. And so then their voice is discounted. That's already happening in the monitoring field. It could happen here. And yet the rights experience of young people is the most important evidence there is. So there needs to be that consultation component, and we need to be sure that this doesn't just become a technical exercise with qualitative data and measurement people in the room. There is a risk that CREA could be used to justify predetermined outcomes. I think we've all known cases where planning processes were decided up front and then the plan was done. I think that's also a risk for CREA. An official once told me that the Universal Child Care Benefit Program complies with the convention if you interpret the convention a certain way. So then I asked her, have you looked at the fact it has an inequitable impact for children of the poor? Well, we didn't look at that part. So, it could be used. And an ideological bias. I would say the best interest of the child is a principle that can be very subject to bias. There is a significant literature on how the worldviews of social workers and psychologists influence their best interest assessment of the child who is their client. And we will have to build checks into any system to ensure that that is not the case here. Right, then I'm going to move on and look at what are some key elements of a CREA. Screening of all policies to determine initial impact and then the scope of a CREA. And that's because if you say we're going to do it for everything, you can just gum up the whole system and then you will get poor outcomes. Some countries are using a screening tool. There is a risk that a certain policy has a big impact when children gets through that, but we think that wouldn't need to be part of it. We've already talked about data and analysis, and I would again emphasize the analysis. And we are hoping that any CREA would have qualitative analysis as well as quantitative, which a little bit comes to your question too of evidence-based. It does need to be qualitative, not just the numbers. Including a voice for children. there is emerging good practice in consultation with children, it's still a big challenge, and it will be a challenge in some of these processes, but we argue it's an essential component. I think I already covered quite a bit that we do it at the stage that there are policy options available, so that options can be considered as part of a CREA. We know from some other countries that when certain negative impacts were identified, adjustments were made in what was on the table, and then something could move forward. So we think it's important that that possibility of options be there, and I think it also makes it more palatable to political parties, right? If you're doing it when there's still options on the table than when you're, taking. I was going to use the sports as an example of unintended consequences, and I didn't know when they decided to give a tax credit to help reduce obesity, a tax credit for sports, right? Give parents a tax credit to enroll your kids in sports. It's a measure to decrease obesity. Well, all the evaluation shows it hasn't done that. But you know what? Somebody made the big announcement before we looked at all those questions, and they're not going back, right? They hung their political hat on it. So if we do it ahead of time, I'm sure we could have come up with a better program than this one if it comes to decreasing obesity for children. Transparency. Transparency in the process is significant. We know a few governments who are actually doing some of these online so that people can see what is being looked at. There are other disadvantages of doing it online, but what results then is a better informed public. And I'll go back to my examples about education policies. Parents get very emotive about the education of their children and what happens. And so if there is a better information out there, we think that would be an important part of it. And then finally, key questions to ask. So there needs to be a template that says these are some of the key questions that need to be asked, whether it's for every area or whether it's for specific ones, but that's up front. And other countries are working with that. CREA can be used by NGOs as well, outside government. Some cities, the city of Edmonton is using what it calls a child lens on policy, which comes close to CREA, isn't quite there, but it's a city, and it's part of the child-friendly cities movement. I would think institutions could use CREA. We would hope educational institutions might begin to look at the child rights. So it can be applied by different bodies at different levels. So it isn't just one jurisdiction or one governing body that would use a CREA. All right. What are we learning from other countries? It is a new field. There's not a large body of literature yet, but I've listed on the overhead the countries that are using it in some way or other. Belgium, Sweden, Scotland, UK, New Zealand, cities and NGOs. So if you look at that, you see that that's a range. They're not all governments of one ideology using it. They're not all big states, not all little states. But we are in early stages, so there is limited evaluation of its usefulness, that you could really hang your thesis on yet. You can write a thesis, but you can't hang a thesis on it yet. In many countries, it is part of national plans of action to implement the convention. So the country has first put in place a national plan of action, and an CREA is part of that. That does somewhat shape it. We don't have a national plan of action in Canada. We had a pretty weak attempt along the way, and actually it's the coalition's position, just forget about it and get on with implementing the convention. So we don't have one in Canada. But the evidence would say that it has added value to specific policies. That's very clear, that doing CREA has added value. And another one is gains in awareness of children's rights. That's universal. Almost every place there's been a look at the use of this, they do talk about the gain in awareness. I'll talk about just a few other lessons for the outcome. Can I go back? For the outcomes. Increased awareness of children's rights, I've mentioned that already. It has fostered coordination between departments. So for example, when you look at the impacts of a policy in one department and you see that that influences another department, the experience is elsewhere that it has fostered coordination between departments. The experience suggests that when there's a legislative basis for it and when there's a high level of commitment to it, it's more effective. That could be an issue in Canada. If we continue to get mid-level officials doing this work and we have no commitment by deputy ministers, people who actually have their hands on the policy levers of government, we could face that. Because it tends to be where they put rights, sort of as middle-level officials who sit on committees. And, they're great people, but they simply don't have the clout in the policy-making decision. And other countries would confirm that you need either that it's there by law, which some countries have done, it's put into the law, you must do one, or there is a high level commitment to it. Those are one. Lessons for the process. It needs to be a bit of a robust process, and there need to be adequate resources to it. I saw one country that proposed that 1% of the budget be allocated to the impact assessment. While that gives you a measure for, putting resources toward it, that may work for programs, but you know what? Sometimes there are laws that don't have a big dollar figure attached to them that have a huge impact for children. So I would hate to see that only used as a guideline because, you may miss a lot of things if that's the case. Guides, manuals, templates, good practices, all those things are emerging in countries that are using them. So we're seeing that come forward, and those are helpful. You need to have some templates, some guides for it. Training in the technical skills is emerging as a need from countries that are doing it. Then this question of using inside and outside government. Some of the countries that are having the most benefit, and again, this is hypothesis, not that evaluated yet, is where it's being done inside the government, but it's also being done by a children's advocate, for example, or somebody who is assigned to monitor policy. So in our circumstance, you might see in a province like New Brunswick, the process done by the government, but the children's advocate doing a bit of a shadow process. So you do have that independent. UK, you see a lot of CREA being done by the children's advocates and bringing it to government. But where it's owned and where it's outside, that would be the best. I once challenged the University of Ottawa, to do a CREA of Bill C-10 and bring it to the government and say, we did it for you since you didn't do it, but we didn't get that done in time. We also know that other measures of implementation strengthen CREA. Again, I want to emphasize, we see it as one tool in a toolbox. And we're not dropping the advocacy for other tools in Canada, but we do think this one has some potential to move forward. So you get the tools you can get, right? And then you keep working for the other tools. But we're not pushing this forward as the only thing governments should do. And then we believe that CREA could be an asset for federalism. There's a paradigm shift happening in the government's attitude toward human rights and federalism in Canada. For many years, we faced the argument federalism is an obstacle to implementing human rights. So every time we'd ask the federal government, what are you doing about children's rights? They would say, we can't do that because it falls in provincial territory. It falls into provincial jurisdiction. We still faced a lot of that in the third review. A lot of it. I bet you if you went through the tape and counted the number of times they said, that's under provincial jurisdiction, can't do anything about it, I'd like to add them up. We still face it, but there was also a paradigm shift evident in the third review, which is arguing that diversity and devolution is an advantage for human rights because actions are being taken closer to where children are. We can have diverse solutions. And what did we see at the reporting stage? They held up an example of one province and said, this is how we're implementing children's rights, see how good it is. On child care, they actually turned to the representative from Quebec who outlined the child care program in Quebec. And they held it up as this is Canada implementing its children's rights obligation. When we talk to the government about childcare, we hear all the time, we can't replicate the program from the government of Quebec anywhere else in the country. But they get by in the reporting stage with holding up one provincial example and saying, this is Canada implementing children's rights. And the UN committee doesn't understand about 12 provinces and 2 territories. So it's, you know, so they drop the language about it's a barrier and are kind of using it's an advantage. One of the humorous things, they actually held up some programs that have been cut as good practices. That was a bit funny. But the other thing is questions like equitable treatment never come on the table that way, right? So they can hold up a good example from one province doing something for a certain group of children, whether it's Aboriginal children, refugee children. Well, what about equitable treatment for similar children in other provinces? It just doesn't come on the table. I guess where we'd like to go as a coalition is to stop that debate and move to another page and say rights-based tools like CREA could be an asset for federalism in Canada. So instead of arguing about is it a barrier, is it not a barrier, and that game, we think that rights-based tools could be an asset to federalism. And that's an area, frankly, for exploration for the coalition, for research. Those of you who are into research, we welcome anybody who wants to join us. Let me just say a little bit about why we think it could. Rights-based tools are centered on persons, not levels of government. So, for example, in the case of Aboriginal children, and many of you may know about Jordan's principle, that, you know, the child should get the health care he needs and the two governments should fight about who pays for it afterward. All of the discussion, when it's government to government, ends up being between those two governments. And all the focus is fighting between the two governments. And even our social union agreements are between the governments. People aren't in the picture. Rights-based tools start out with persons, not levels of government. And I think the more tools we can put into place that start with rights will do that. And by the way, I'm running short time. You know, we're moving our report, and I can leave a copy for you. Our report to the UN wanted to see children's rights named in the 2014 Social Union Agreement between feds and provinces as a way of perhaps everybody agrees to the convention. Could we use it to ensure what happens with the Social Union Agreement? The truth is, there probably won't be a real agreement. So we were advised there may not even be such an agreement. But we think it's still worth pursuing. Rights tools do look at results and outcomes, not just how many dollars have been spent. But it's not national program standards. National program standards is not going to happen in Canada. I know some people still advocate for it, but I think there's a way of getting at results and outcomes against human rights indicators that doesn't need to be national program standards. So we can respect diversity and flexibility, and certainly Aboriginal peoples want diversity in how they will implement rights in their communities, as do other groups. But it also puts a spotlight on things like equitable treatment. It can allow for comparisons to establish good practices. When the government was asked to explore equitable treatment, we said, why doesn't the federal government publish a report what's happening to children across the country? Just even doing that comparative study would promote equitable treatment, because no province wants to be the worst in Canada on something. And it would promote greater accountability for public dollars spent. When I ask MPs, you know, can you tell me what's actually happened with the transfer dollars you gave to the provinces for children? They can't. Isn't that an issue for our elected leaders? They really can't track the money. Rights-based tools can give you measures of the real impact for dollars spent. And so we think it could be an asset to federalism and maybe get us out of the endless debate in Canada, because those of us who work on children's rights are tired of it. every children's right ultimately falls federal, provincial in some basis, and we're not winning on this front. So we think maybe we could shift the page. Now, you may tell me I'm dreaming in Technicolor to think that's ever going to happen, but I'd still like to hold it out as a goal.